All right, we are here for oral arguments on State of Ohio versus Joseph Mosley, case 19AP0016. Each party will have 15 minutes during which to present your arguments. The appellate may reserve up to 5 minutes for rebuttal. If you wish to do that, Mr. Ludwig, just let me know before you start your argument, and I'll try my best to track the time for you. These arguments are being visually and audibly recorded as well as being live streamed. You should not use the names of any victims or witnesses or minors. And we have read your briefs and we are ready to begin when you are.
Thank you, Your Honors. I'd like to divide 11 into 4, if I may.
All right.
My name's Mark Ludwig. I have the privilege of being appointed by the trial court to represent Mr. Mosley. Mr. Mosley, throughout these proceedings and to this day, maintains his actual innocence and seeks a new trial. I would like to stop briefly and first point out the professionalism of my opposing counsel throughout this matter. I appreciate her cooperation as well as her zeal in this case. This is a horrible case in the sense of it's an anal rape and vaginal rapes of 2 Caucasian 12-year-old girls by a tattooed black man, who, by the way, is not Mr. Mosley. And to our knowledge, the only 3 black faces in the courtroom in Wayne County were defendant and his trial counsel. Assignment of error 1 concerns the jury instruction on reasonable doubt. And I mention the racial issues because that is an environment we cannot ignore, whether it's a particular assigned error. The jury instruction in this case on reasonable doubt was just flat out wrong. The judge instructed the jury that before it could find Mr. Mosley not guilty, it must find that all elements of crimes were not proven. That's clearly wrong. In fact, page 13 of our brief, we cited Chief Justice Rehnquist's comments about, remember that errors in reasonable doubt instructions are a breed apart and must be examined on appellate review as such. Most egregious in this case, what was wrong here, this wrong charge, was done by reading what the state wrote. This is a jury charge the state invited in writing. Its motion to include this charge contains that error. And as often happens sometimes, however rarely these trial judges might do it, they go ahead and read what was handed to them. And in fact, Judge, we started to read this correctly. He started to read it saying, any, and then he realized what he was reading, corrected himself, and changed any to all, emphasizing that way the change, inadvertently, but emphasizing the change any to all. Again, what sets this case apart is that, number 1, the state invited this error. Number 2, it appears from this record that the state's charge, at least the ones I see in the record, was never signed electronically or physically as served. And this record also reflects there was no opportunity to object to the jury charge provided post the giving of the charge. So those items are special in the sense of they only enhance the error. And again, if you ever have a case where this happens again and the state didn't invite it, it was a slip twixt the lips, that'll be a different matter to handle. The state invited this error. Now, the state's response quickly is to represent, I cite the Hessler case, I believe. The state cites that Ohio Supreme Court case where the court did the opposite. The court said that you can find somebody guilty if they proved any element of the offense. And the Ohio Supreme Court found that was not prejudicial in that case. Let's take a look at the quick background of that case. That error in that charge, any element, occurred in one count of attempted murder. Now, in the Hessler case, there were 4 murders correctly charged, the death penalty imposed, and there were 3, and I use the court's words, there were 3 or 4 attempted murders, only one of which was incorrectly charged. It is in that context that the Ohio Supreme Court said, there's no error here on the one count of attempted murder. That is not this case. Not only is it the converse, we're not talking about anything other than rape, horrible rape of 2 girls, and the defendant is charged saying, if you can only find him not guilty if they failed to prove all the elements. That structural flaw, whether you want to call that structural, de novo, abuse of discretion, or plain error, whatever standard you want to apply to that, okay, it's wrong. And it hurts its reasonable doubt. There's nothing more fundamental. Second assignment of error we talked about was new trial. There were 2 separate motions for that. No hearing was held on either. Again, these new trial motions often come to you with no record whatsoever besides the original trial record. That's unfortunate because a record's deserved. The first grounds for new trial was this 125 Earths fallacy. Now the simple way to explain that only this simple brain can handle. I don't do well with all this DNA. But the 125 Earths fallacy is what's called basically source attribution, which is basically, since our test reveals this could only be 1 in a trillion people made this contribution, therefore, and this contribution appears in the room, doesn't appear on any victim, and this contribution appears in the room, therefore, he must be the source of this, and therefore he is the defendant. Now that is the proper defendant. The judge actually went so far as to actually get this out of the expert witness. I think it's day 4, transcript 188, the judge said, I have some questions, ma'am. The 1 in a trillion number, does that positively identify the individual as the most likely source of DNA? Now, only a lawyer or a judge, with all due respect, can use the phrase positively identify as most likely in the same sentence and have that pretend like it makes sense. But positively identify, and the witness answers, I don't do what's called source attribution, which is to say somebody is that profile. Then the witness went on, and no objections raised, I don't deny that. Then the witness goes on and says, but having a profile rarer than 1 in 1 trillion highly indicates the person is likely the contributor. Come on. Now, when did we change from 2 12-year-old girls point at someone in a courtroom and say, that's the man that raped me? When does that become icing and the cake become DNA evidence? When did we get turned around like that? We used to have a rape case tried simply by someone saying, that's the person who raped me. Now, all of a sudden, DNA, which everyone holds out as supposedly, people go into a courtroom thinking DNA is used to exonerate. Baloney. In all due respect, DNA evidence has become the inculpatory evidence, which makes it all the more dangerous. Again, what is this case about? The state chose the position that this case is about a wedding cake. Cake is the DNA. Cake is the substance. The girl's identification was just icing on the cake. where have we gone insane? The DNA, if you'd argued it was the different way, if you'd argued, look, these girls identified this guy, and oh, by the way, the DNA is the icing that adds to it, that's a whole different theory. This DNA evidence, that's the first 125 Earths fallacy, and that permeates this trial. And trial counsel objected to it at different stages with different variation, trying his best to point out this 125 Earths was wrong. There's two other errors in new trial denial, and that is Mosley wanted to testify, and one of the jurors said during discussions, Mosley should have testified to explain how his DNA got on a sock. Now, I understand that is post-verdict. I understand that. Please note that at that point in time, the jury had not been formally discharged on the record. But, and again, I understand that affidavit is by counsel who is in the room, but what that affidavit says is that the prosecution and the judge was in that room when that juror said that. And at that point in time, excuse the reference, Your Honors, but the referee judge should have thrown the flag right then and said, what are we going to do about this? Does anybody, I don't care if the judge says, what are we going to do about it? And he gets 2 or 3 suggestions and he denies them all. But the opportunity to be heard when the judge himself and the prosecution heard what that juror said, he should have testified, and the fact that he didn't was important to me. The final,
Mr. Ludwig, you're at your 4 minutes. You're welcome to continue. I just wanted to let you know where your time is.
Thank you. I'm sorry. The final thing was the STD reference, and the STD is defendant had it, the prosecuting witnesses did not, and the answer is, well, the defendant knew he had it. Well, wait a minute. This is not about what the defendant knew. The STD issue is about what the state knew. And what the state knew is that he had it, they were treating him for it in jail, and that the girls didn't. And that's important. We cite a case where the opposite happened. The victims had it and the defendant didn't. And that was found to be a Brady violation. So,
Counsel, I have a question for you on that STD issue. When you say the state knew, do you mean, you're not saying the prosecutors knew, or are you saying that the prosecutors knew?
I'm saying they're fairly charged with what the sheriff's department knew from treating him in the jail.
Well, let me
They're fairly
ask you,
charged with that information.
How does HIPAA play into this?
I've never researched that, Your Honor. But
I guess I'm wondering how, if an inmate is being treated for, I think it was chlamydia in this case, how, what would the ramifications be of the treating doctor or nurse, spreading that information?
Well, again, I've never researched that. There may be some exclusions once we become a prisoner, all right, in terms of our rights under HIPAA. I don't know. I've never researched it. And secondly, the quick answer is the states never raised that as a reason we didn't know that. The state didn't raise that in response to the motion for new trial. Perhaps that, Your Honor, we could have briefed it and had a hearing on that subject. And that's one of the things of which we complain. I thank the court. I'll try and leave my 30 seconds for reply.
Oh, you got more than that. Okay. All right, counsel, whenever you're ready.
Good morning. Thank you, Your Honors. May it please the court and counsel. Andrea Uhler for the state of Ohio. As the court is aware, the facts of this case are simply egregious, and the theme is consistent. All of the assignments of error are meritless. Joseph Mosley stands properly convicted of his egregious crimes against these 2 minor young girls, and he has been properly sentenced to prison for not less than 100 years, nor more than life. I'll focus where defense counsel began with the jury instructions, saying that there was a faulty reasonable doubt instruction here. The defendant has conceded on appeal that his trial counsel failed to object to the jury instructions. The proper standard of review, therefore, is plain error. The error must have affected the outcome of the trial. Here, the erroneous jury instruction simply did not affect the outcome of the trial. The defendant argues and urges this court to judge a single instruction to the jury in artificial isolation. That is something this court simply cannot do. A reviewing court must view the instructions in the context of the overall charge. Here, verbally, with the exception of count 5, as I detailed in the brief, that would be the kidnapping charge of AF, the trial court gave the proper not guilty instruction. It said if you find the state failed to prove any of the essential elements of the offense, of name of the offense and the charge, your verdict must be not guilty. That is correct. I say that verbally he didn't give count 5 because the not guilty reading is skipped over in the transcripts as to count 5. In the written instructions, count 9, which was obstructing official business, was the only written instruction that was incorrect. It provided that if you find the state failed to prove beyond a reasonable doubt all the essential elements of any one or more of the offense charged, your verdict must be not guilty. The state has conceded that this was incorrect. As counsel pointed out, the trial court was reading along through the instructions, started to read it properly. It appears that he corrected and went along with that. Again, that's on count 9, the obstructing official business charge. All of the other 8 charges, which we had the 2 counts of rape and then 2 additional counts of rape of a victim under the age of 13, 2 counts of kidnapping, the 2 counts of robbery, all of those had the proper jury instructions. In State v. Hessler, which is 2000 Ohio -30, the trial court did give the opposite instruction. The trial court advised the state could prove any of the elements of aggravated murder to get to guilty. That's even more egregious than this slip of the not guilty instruction in my mind. The court held, the Supreme Court held, this was not plain error. Sorry, I just want to make sure that I did have that. It was Supreme Court. That was not plain error. They said the instruction as a whole clearly conveyed the state's burden to prove every element of the offense charge to get to guilty, plus trial counsel all but admitted in closing that the evidence was overwhelming and no other result could have occurred. Here, the instruction as a whole clearly conveyed how to get to guilty and how to get to not guilty. Plus, when you look at the evidence overall in this case, looking at the manifest weight arguments that was raised by counsel and the states responded to, the evidence, DNA evidence, and the other evidence is very compelling in this case. You don't get to another result simply because of the trial court's error in this instruction. I would also note that counsel has brought up that Criminal Rule 30, that there was never an opportunity to object to the jury instructions outside of the hearing of the jurors. You have to actually object to get that opportunity. You also have to, in order to, I agree that the jury charge that's part of the record or the jury instructions, they do not have the signature of the certificate of service. But in the end, that's inconsequential since we're here, if anything, on plain error. And when you go through that plain error analysis, you can't get to that the outcome of the trial would have been different. And simply under Criminal Rule 30, in order to raise an objection with respect to jury instructions, counsel had to do that before the jury retired to consider the verdict, and that did not occur here. Moving on to the motion for a new trial, the counsel set forth 3 separate reasons why the motion for new trial should have been granted. The first he's focused on being prosecutor misconduct. He also focused on juror misconduct and the newly discovered evidence / Brady violation. For prosecutorial misconduct, the test is whether the remarks were improper, and if so, did they prejudicially affect substantial rights of the defendant? No improper remarks occurred here. The trial court recognized that the state elicited this testimony at trial. One of the experts that the state called testified, basically the state used the 125 Earths analogy when discussing the DNA evidence at trial. BCI experts had established that there are approximately 8 billion people on Earth, that there are 1,000 billion and 1 trillion, and it had been set forth that the likely one of someone having DNA profile the same as Joseph Mosley was 1 trillion in this case. And then when you divide 1 trillion by the 8 billion people on Earth, you get that 125 Earths fallacy, or not fallacy, analogy. The trial court specifically noted in denying the motion for a new trial, that the state's, it was consistent with the evidence that was presented. And prosecutors are entitled to latitude as to what evidence has shown and what inferences can be drawn from the evidence. The DNA evidence in this case was properly admitted, and the prosecutor's argument was a reasonable theory which represented that fair inference based on the record. Looking at the juror misconduct, following a verdict, claims of juror misconduct cannot be raised solely upon the statements of jurors, but they must point to some competent, credible evidence from some other source. Evidence Rule 60CB captures this rule. Here, the defendant's attorney submitted affidavits alleging what the jurors said following the verdict. And as in State v. McKnight, 2008, Ohio 2435, the defendant's attorney's affidavits amounted to complete hearsay. The affidavits are incompetent in this case. With respect to the newly discovered evidence, there's nothing newly discovered about the evidence the defendant asserts was newly discovered. It was the defendant's own privileged confidential medical records that were not in the possession of the state and which were not remotely relevant to this case. The trial court aptly noted that the newly discovered evidence would not change the outcome if a new trial was granted. The defendant simply failed to meet any of the prongs to qualify for a new trial under that Criminal Rule 33A6. None of the 6 prongs were met. In the same vein, the defendant also argues that the state committed a Brady violation by not disclosing the so-called newly discovered evidence being Joseph Mosley's personal medical records. Not only has the defendant failed to meet his burden to establish a Brady violation, but there's no suppression and thus no Brady violation if either the defendant or his attorney knows before trial of the alleged exculpatory evidence. The defendant was clearly aware of his treatment for chlamydia while he was incarcerated at the Wayne County Jail. This argument is meritless. And as to the HIPAA point, I would argue that the individuals providing medical care to Mr. Mosley at the Wayne County Jail would be prohibited from releasing that information without a release sign by Mr. Mosley. And we don't have that in this case, to my knowledge. In the third assignment of error, Mr. Mosley argues that the evidence is against the manifest weight of the evidence. The DNA evidence and the overall evidence in this case was compelling. The state presented testimony of 3 forensic scientists, among other witnesses. Of paramount importance, the DNA evidence demonstrated there was a rape kit submitted of AF. There was amylase in the mid-crotch area, underwear submitted. Upon further DNA analysis, more than one person was present. The DNA was consistent with AF. There was additional data that included a male, but the sample was not sufficient for comparison. YSTR testing was done of that same underwear, and it could not exclude Joseph Mosley or any of his paternal relatives from the front and back panel of AF's underwear. This is not expected to occur more frequently than 1 in 700 males, was the testimony at court. There was a rape kit of TC. Underwear tested presumptive positive for blood in the mid-crotch area. Further DNA analysis was conducted. Again, the same, there was more than one individual present, consistent with TC, not enough additional data to compare to see who that individual or what that DNA may be. But there were 4 separate socks that were also submitted for testing. Semen was identified on one of the socks. The sock had a DNA profile in the sperm fraction that was from a single person, and it was consistent with Joseph Mosley. With the sperm fraction of the sock was rarer than 1 in 1 trillion. That's where we get that 1 in 1 trillion number. One of the experts testified, I would expect that only one would have a DNA profile consistent with that. Sorry. That means if I tested a practice, would have a DNA profile consistent with that sperm fraction. In addition, a washcloth was examined, and there was semen identified in the washcloth. The washcloth contained a mixture of 3 major contributors: victim AF, victim TC, and the defendant Joseph Mosley in the non-sperm fraction, and 1 profile in the sperm fraction being consistent with Joseph Mosley. That was the compelling DNA evidence. In addition, the defendants both testified at trial, and their versions of the events corroborated the horrific ordeal that they went through that night. They were knocked to the ground. AF was knocked to the ground with what was believed to be a black gun. They were both ordered at gunpoint to the side of TC's home, where they were robbed. TC fell through the cellar door into the basement. Both were ordered into the basement, ordered to take off their clothes while standing side by side, witnessed each other being forced to perform oral sex upon the perpetrator, and to stand there while the other was anally raped. The light was on in the basement. They testified, although dim, they could see their perpetrator. Both identified Mosley as the perpetrator at trial. The jurors heard testimony that AF and TC separately identified Mosley as the perpetrator when presented with a photo lineup array one day after their horrific ordeal, and each identified Mosley as the perpetrator with a confidence level of 9 out of 10, 10 being the highest, as the man who had robbed, kidnapped, and raped them at gunpoint. Jurors also heard testimony about executing a search warrant on the property. They found a CO2 canister in Mosley's trash can, which is typically used for soft air guns that are black, resemble a semi-automatic firearm. And they heard evidence that the attack occurred approximately at 6 p.m. as the girls were returning from McDonald's, and that Mosley's phone records showed that he did a search for a police scanner at 7:16 p.m. This is simply not the case where a manifest miscarriage of justice occurred. With respect to the denial of the right to testify, defendant asserts his constitutional rights were violated because the trial court failed to inquire at the close of the defense's case whether he knowingly, intelligently, and voluntarily waived his right to testify on his own behalf. The defendant recognizes that in State v. Bay, the Supreme Court rejected this exact argument. A trial court is simply not required to conduct an inquiry with the defendant concerning the decision whether to testify in his defense. And I believe, and now I don't see it, I think it was State v. Fry, was a 9th District case that also had part that went to the Supreme Court that he talked about in the brief. And in that case, there was nothing in the record that showed that the defendant wanted to testify. Here, Mr. Mosley argues that, well, I never was asked and I would have testified, and he said that at sentencing. Well, that's too late. You had your opportunity during trial and you didn't say anything. You were represented by counsel, and the record's devoid of any indication that you spoke up and wanted to testify. And in Fry, the court said, basically the defendant's acquiescence to sit there and not say anything confirmed, or at least supported, that he was not denied his right to testify. With the argument that the sentences are contrary to law, or the sentence is contrary to law, the allied offense argument is that the rape and kidnapping convictions should have merged as allied offenses. Well, we know that nothing could be more inaccurate. It fails the allied offense test. These were separate acts committed against separate separate victims. And the defendant argues State v. Bridges, where he asserts that the rape and kidnapping should have merged because they occurred simultaneously, in essence. It's not the case of Bridges here. Here, the defendant, in Bridges, the offenses were merged because the kidnapping was the force used to hold the victim down. Here, Mr. Mosley kidnapped the girls at gunpoint, forced them into the basement cellar of a dark, cellar basement, and then he proceeded to rape them. Those are separate acts.
Counsel, with that, your time is up, unless you just want to do one wrap-up sentence.
Overall, Joseph Mosley has failed to present any arguments in this case that have merit on appeal, and he stands properly convicted of his egregious crimes, and his sentence is appropriate.
All right. And Mr. Ludwig.
Your Honor, if it please the court, I heard the word suppression. I'll reply quickly to that. If you'll take a look at the effective assistance of counsel arguments, you'll see that the original interrogation of Mr. Mosley was agreeably suppressed. The state agreed that that interrogation was wrong, and they agreed not to use those statements. That was with prior counsel. New counsel comes in and does not say a word about the protection of the Ohio Constitution, State versus Ferris. An unlawful interrogation also includes derivative evidence in Ohio, not in the federal system, but in Ohio, it includes derivative evidence. When they unlawfully interrogated him, they took a DNA swab. They used that DNA swab then in the rest of their case. That's why you start with ID and not DNA, because even if the DNA falls apart, if it was icing, you'd still have a cake. That's the difference here. Secondly, at some point in time, we've got 9 separate counts that are, one of which is said wrong. She says, the prosecution argues. We're talking about the overall portion of the charge. Overall, the quote that she gives, the judge is telling them on all of the charges, overall those charges, it is, you must find all elements. If you find all elements of any offense, he's not just talking about number 9. So we're talking about the overall charge, 9 counts, one of which they admit is wrong. The overall charge is wrong. So that's 8 out of 10. Now, if 8 out of 10 is an A, if 8 out of 10 is beyond a reasonable doubt, then give them the A. But I never got an A getting 8 out of 10 things right. And that's all they got right, okay? Your Honor, so please the court, something has got to be done. The effective assistance of counsel on appeal is also an important factor. In November of this year, I filed a motion, and God willing, in November of this year, I'll be 47 years in practice, if the Lord lets me stay. In November of last year, I filed a motion to incur costs, saying, with my experience, I still need a DNA expert to consult with on appeal. And again, the state didn't oppose that. I need copy costs for 1,000 pages of discovery that I didn't get to, that I was not supposed to see, but I wanted to get copies of. And I'm denied an interim award fees. This kind of attention to what kind of appellate counsel you're getting has got to be addressed. And listen, I'm more than willing to spend 4,000 hours working on a case for $4 an hour. But you're not going to get youth. You're not going to get fire that deserves this. Years ago, John Lauer, I think, said to me—
Mr. Ludwig, I let you have extra time because I had interrupted you on questions, but you are well past your time now. All right. Thank you for your arguments and your insight, your final comments there. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted online on our website and that of the Supreme Court. Our